is up, everybody? Welcome to the Transparency. Good morning. We are going to take a look at some new documents here in the Karen Read case. So let's see what we got. I'm not too interested in the Supreme Court's decision. I knew she wasn't going to win this. There's other ways to do this, but let's see, 1, 2, 3, 4. But I am interested in talking about the facts about the investigation. I love this investigation. It's crazy. So welcome, everybody. Good morning. Good morning. So fresh and so clean. Good morning, everybody. Hollywood, say it ain't so. Cincinnati loves you. Oh my gosh, 24 months. Give a shout out as well to Boston as a member for 41 months of the channel. So 24, Hollywood OG, you know it since he loves me. All right, look at this. This is not the cleanest version. Let me see if I can clean this up. Like, whoa. Like, we blinded over here. Okay, let's see. Is that cleaning up any better? I'll make it bigger. Bigger is better. You guys remember when I was playing around with all the all these? Well, basically, this is in a nutshell what's about. So, suck it to me, baby. Yeah. Okay, so Karen Read. Now comes the defendant, Karen Read, and respectfully moves to this honorable court pursuant to Brady versus Maryland. You guys know what Brady versus Maryland is, right? Brady. We were asking for you to compel the Commonwealth to produce the video surveillance footage from the Canton Police Department between January 29th at 12 midnight and January 29th to 11:59 p.m. All metadata and logs associated with therewith in a forensically sound manner. That's going to be a key phrase right there that we're going to be talking about over and over. In a forensically sound manner. So it's everything where the Sally Port came from. Okay. It's so that this evidence can be turned over to the defense. I'll be moving back onto this page in a second, but on January 22nd, 2025, so just recently, the Commonwealth disclosed for the first time that additional video surveillance footage taken from the Canton Police Department may be in the possession of law enforcement on a retired detective's work computer. Unless the data at issue is properly forensically imaged and preserved, the corresponding logs relating to the video surveillance footage, which would contain the identity of the individual or individuals who access the surveillance system, the date of the download, and underlining metadata. So that's going to be key right there. It will let us know like who was accessing this, which should contain the identity. Okay. Of people that would have been coming and going to see who, in fact, who was there. We need to have everybody accounted for so we can figure out who did what, who's been breaking off pieces of this video. Because this video was 100% downloaded in its original form during this time of, midnight to 11:59 p.m. Oh, Sherry D, what's up, girl? Hey, Sherry D, do you have us in a bigger format? This, if so, hit me in the emails. Galaga. She says Galaga? Galaga? So moving on. But the big thing is we want the metadata associated with the actual files because they will be destroyed if we don't do this. The Commonwealth has indicated that it is objecting to properly forensically imaging the computers and or department's video file systems such that the defense can obtain a forensically sound copy of the requested information. Again, we're hearing repetitively this forensically sound copy. Like we need it to be forensically properly done so that we can properly get it to our person to be able to see if things have been manipulated, destroyed, altered. The metadata underlying the video files at issue is not only central to this case, but it's also exculpatory, meaning it will prove that Karen Read, it's exculpatory to Karen Read because it will prove what the heck they did to frame her, basically. And if properly imaged, will potentially reveal significant exculpatory, relevant, and material information about the underlying data. Namely, the dates of creation. Remember, I talked about this the other day. We need to know what date this was created. Is this the copy I sent you? No, I did the one that Murky sent me, but I realized that this is on a way smaller, like the page is way larger. And so I was, maybe you could just read. I can use that one then. Me and Murky, when we do our messagings back and forth, for some reason, we always get the weirdest stuff going on. And as much as I love the little people of the world, I need my documents to be big. So, you guys, Hank Brennan is objecting to this. All right. So the reason that they really want this is because the material, this information about the underlying data, namely the dates of creation and information pertaining to whether any of these files were altered in any way. It is absolutely necessary that this information be obtained in a forensically sound manner. I told you, like, they're just going to keep on repeating this forensically sound manner. And it's because they got it from somebody, like, to say, like, hey, use this lingo because this is what we do in the forensic world. Next, why this is important. Unless the Commonwealth images the device at issue and obtains this critical evidence in a forensically sound way, you guys, we're going to play a new game. Every time that they say forensically sound, we are drinking. All right, forensically sound, forensically sound. The Commonwealth will deny Ms. Read access to exculpatory information, which underpins some of the most highly contested and important evidence in this case. The Commonwealth's proposed process will destroy critical evidence, namely relevant and exculpatory metadata underlining these video files, in violation of Ms. Read's constitutional right to effective assistance of counsel and to due process under the law, as guaranteed by Article 12 of the Massachusetts Declaration of Rights and the 5th, 6th, and 14th Amendments to the United States Constitution. Oh, gosh. Screenshots. Yeah, that's what we got. We're dealing with screenshots over here. I love screenshots. Oh, let's see. Let's see if these will help us. Oh, here we go. Oh, we might have more. Dude, every single day, all they do is just file shit for Karen Read. What number is this? Gosh, Hank Brennan filed something February 7th. But we're not looking for that one. Let's see. We're looking for number 483. Let's see. Sorry, we're in the... God, the printer's just going crazy. Sunshine and rain. We got more Karen Reed jurors coming out saying, yo, everybody's getting hosed. All right, I'll just continue on. Oh, thank you there, Sherry D. As I was saying, in addition to her constitutional rights, Miss Reed also has a statutory right to obtain evidence in advance of trial and prepare her defense. Massachusetts rules of criminal procedure clearly state that the Commonwealth must provide certain mandatory discovery of evidence within the quote-unquote possession, custody, or control of the Commonwealth to the defense in order to meet its discovery burden. Information subject to such mandatory discovery includes all material and relevant police reports, photographs, and underlined would be tangible objects or items. Penny the printer, come on, baby, you got this. Reports of physical examination of any person or scientific tests or experiments, stuff like that. This is all part of like the rules. As well as any facts of exculpatory nature. This video is definitely exculpatory, but I believe it's inculpating. Not only is this video exculpatory for Karen Reed, but I believe that you could say that it's going to inculpate people. All right. Also, clearly, Higgins is on the phone talking to somebody, y'all. That phone call, people are saying, is it Brian Albert that he's talking to? Is it not? I went back to listen to Brian Albert's testimony. Have you guys taken a look back at Brian Albert's testimony? Like, first of all, does he have a tick? No offense, but it's wild because we're going to have a Brian Albert day. I just need like a video editing guru next to me here. I mean, it is ridiculous. But after hearing Alan Jackson say, like, listen, we questioned everybody the way that we did on the first trial because it mattered, which it did, if there was going to be a trial 2 or an appeal. Okay. And so after hearing, homeboy say that, I agree that, yeah, you had to ask questions the way that you did, but also, like, I mean, these people's testimonies, like, we were all loving the fact of ringing the bell, like, oh my God, here's Jen McCabe. She's taking the stand. Here's this person. Here's that person. But can you imagine what the jurors were going through, having to sit there and listen to all of this crap? Like, what does any of this mean? We all know what it means, right? We're all like, yeah, give us the tea. Woo! Bingo with Bev, But the jurors, they were totally lost. And you can't tell me that they weren't. But to think that Hank Brennan is objecting to this material, which is, let me put to you guys in layman's terms, we have a hard drive. You want to forensically image it. You want to forensically image my phone. Okay? Objection. Why would you have an objection to that? How, if you're Hank Brennan, do you have an objection to that? Like, what? Excuse me, but what the fuck are you talking about? There you go. There's an F-bomb for you. Take that one to the bank. So, yeah. Continuing on. So, Reed respectfully requests that this court order the Commonwealth to provide the requested discovery to which Miss Reed is entitled to under Rule 14, the Massachusetts Declaration of Rights, and the United States Constitution. Okay. This is very important because this is how stuff got ruined before. Remember? They were asking for, hey, preserve your phones. And then when they came in there, oh, I destroyed mine. Right before this was coming. So here's the factual background. This is what the layman wants to know. Let's talk about the facts, the factual background. Miss Reed is accused of the following arising from and out of the death of Officer John O'Keefe: murder in the second degree, manslaughter while under the influence of alcohol in violation, and leaving the scene of personal injury and death in violation. On October 5th, 2023, this court ordered the Commonwealth to produce all video evidence obtained in connection with this case, along with all associated metadata. So those of you guys that are keeping a list here, you'd want to take your little handy dandy pen, and we would put down October 5th, 2023. Okay. First date. Next. And it says, see Exhibit 1. In spite of this standing court order, the Commonwealth recently notified the defense that additional video surveillance footage from the Canton Police Department recorded on January 29th, 2022, and the metadata associated with that footage may be in the constructive possession of the Norfolk County District Attorney's Office through its agents at the Canton Police Department. Agents of the prosecutors are the police that work on the case, whoever would be involved in working on that case at any point in time is an agent of the district attorney. So to say that you weren't in possession of that, that's not going to fly. 483 cent. Oh, Sherry D. Sherry baby. As my ADD is kicking in, have you guys seen the TMZ video of the P. Diddy shit? Holy shit. Me and Bella watched the beginning of it. We started it last night. I died. I'm going to do a reactionary to parts of the clips of that because it's that good. Okay, moving on. Squirrel. Okay, so procedural history relating to the Canton PD video surveillance footage. A brief summary of the procedural history relating to the video surveillance footage at issue is set forth herein. And you could tell that somebody is just literally laying it all out for Bev here. Like, girl, I'm going to walk you through this. Okay, I'm going to walk you through this. And I believe, and so does Bella, we believe that Little wrote this. We believe that Little wrote this. Okay. So the Commonwealth has provided the defense with the CPD video footage on 3 occasions. So 3 times. And on those 3 times, let's see if she gets into it here. On April 4th, 2024, shortly before the first trial in this matter, the Commonwealth produced footage from the CPD main driveway. So that would be the 4th, and it is the 4th, and we're getting the main driveway. Okay. CPD video, aka Sallyport area. Okay. Let me back this up just a tad because we're doing our timeline for everybody. Now, so the Commonwealth produced footage from the CPD main driveway and Canton Police Department Sallyport front wall. For the very first time. For the very first time. Okay. The Sallyport front wall footage provided by the Commonwealth omitted, so this run, it omitted the 42 minutes. Okay. It omitted the 42 minutes. And that's the interval during which the SUV arrived at the Sallyport. And where you guys can get all this from is right here, right in the docs. Okay. So I'm just breaking it down. If people like the little notes, it may help them. And you can find this information. She says, go get the trial transcripts, and it's right there. So she's citing everything, which is like really just matter of fact to it. Then the missing footage could have been used to show the condition of the SUV's right tail light upon arrival at the Sallyport, and to date would be the only footage that serves this purpose. Trial transcripts at volume 28, 32, 10 to 33, 40. The condition of the right rear taillight of the SUV at the time is it entered law enforcement custody is perhaps one of the most critically and highly contested issues of this case. Okay. Next, mid-trial. So here we are, mid-trial, and it would be on this date via a share link. So shareable link. It was additional Sallyport video download. This is the additional. The Commonwealth produced additional footage from the CPD Sallyport back wall. This is at trial then. This is when Bukaki testified on direct examination. So this is when Yuri testified to video being an exact replica. Okay. And it wasn't until cross-examination, okay, that this was cleared up. But on cross-examination, however, it became apparent that the video surveillance footage displayed on direct examination was inverted and a mirror image of reality, despite neither the Commonwealth nor Bukaki having mentioned it on direct examination. Therefore, when the video appeared to show a person standing near the left rear taillight of the vehicle, in actuality, that person was in fact standing near the right rear taillight. It remains unclear. So this is one of the things we were always wondering was during the trial, when did the defense become aware that this was an inverted video? Were they ever provided this video? And the answer is they weren't. This is when this came out. Okay. And this is why everyone was like, wow, they didn't think that we would recognize it, you know? Well, one, they didn't recognize it because they had never gotten it before. Okay. They had gotten it on this day in a shareable link that he testified to. First of all, that's like, again, that wouldn't even make it in. That's discovery violation. Or you could play like Alan Jackson did and let it in. And then this calls for an automatic, like, this is Brady. Like, how is this? Not only is it Brady, then you destroyed the evidence because you inverted it. How did this not stop the case right here dead in its tracks when this guy attempted to testify to this shareable link that was shown in direct examination? Well, because Alan Jackson and his team, they had to make all these decisions, which were called, you know, it's strategy. No, let them go ahead and testify to this, and we're just going to blow it up. But not when you have a judge that's just like this, going like this in her chair, you know. And did they make the right strategy call? Absolutely. Absolutely. Because it wasn't just the additional portion. Then the motherfucker was inverted, the additional portion. So now, it remains unclear why this inverted video was withheld by the Commonwealth and produced to the defense in the middle of trial after the initial CPD surveillance footage was turned over by the Commonwealth. So then it comes into, now we ask ourselves, this is when I did it last week and I was like, here guys, we have all of these copies. Okay. So this shareable link right here, that had to come from somewhere because it didn't. You guys turned us over something that was like this. Okay, that's what we got. Then in the middle of the trial, so here's what we got up here on the 4th. And then here's what we got here on the 23rd. But somehow that means that there has to be another one because you would have had to record it and then use this one to invert it. The original that you gave us right here. So you made another copy so that you could then take that copy to fuck with it to invert it, to make this copy. Right? Now, so again, it remains unclear why this inverted video was withheld by the Commonwealth and produced to the defense in the middle of the trial after the initial CPD surveillance video was turned over. Most recently now, post-trial, now, almost a year to the date, because then we go post-trial and we get to October 10th, 2024. Now, post-trial. The Commonwealth again provided new video surveillance footage, this time from the CPD church side. CPD, this is the church side. So again, this has to be like a different camera. Again, the Commonwealth again provided new surveillance. Okay, blah, blah. And it's the church side exit, okay, outside. And it's the first floor corridor. And this is really important because this is, you're seeing everybody go in. Okay. This footage shows Brian Higgins arriving in the parking lot. So this is the Big Daddy footage. So somebody gave this out, said, here, you want to fuck with us, Higgins? We'll go ahead. We have this. We'll go ahead and give this out. So now I started wondering when this came out, I said, oh, shit. I said, this is almost like a F you to Higgins. Okay, because the only person that's seen on this is Higgins, right? So this could be a huge, well, let's fuck with Higgins. Like, because what we see on this, and they say, is that now we have Brian Higgins is seen arriving 1:26 a.m. Okay. And he enters the Canton Police Department and is seen speaking on the phone to some unidentified individuals on the phone. So he's seen speaking on the phone at this time. This is really important because I thought that he was just speaking on the phone at 1:34, but he is on the phone. Very important. We want to talk about the timeline of what's going on at the house. Okay. So he was on the phone at 1:26. Right, Brian has arrived at the parking lot at 1:26. Enter the. Oh wait, I'm sorry. Yeah, and seen. Okay, yeah, that's right. And is seen speaking on the phone. Some on the parking lot as he leaves the Canton. No, actually, take that back. He's seen going in. The way that she words it is not. I don't like it. Okay, so he's on the phone at this time. He's just only seen. He arrives at this time, but he's actually physically seen on the phone at 1:34. Also doesn't mean that he couldn't have been on the phone at some point in between those if he was inside the building. So, whoopsies. And this is significant because this material and relevant evidence, which establishes Brian Higgins was on the phone with some unidentified individual at 1:34 a.m. as he left the Canton Police Department shortly after O'Keefe's death, was withheld from the defense at the first trial. And this is what prevented Karen Read from getting his phone. If this would have been known then, she would have got all their phones. Unbelievable. The video surveillance footage at issue was a major point of contention at trial, in no small part because the Commonwealth was utterly unable to establish any chain of custody for the various clips of video produced to the defense from the CPD. We said this in the beginning. I said, where is the chain of custody with all of this stuff? Again, Alan Jackson could either do one of two things. Well, it's not coming in. There's no chain of custody. Like I've said with the Jennifer Drake 911 calls, there are no chain of custody with that. None. It just poof. They just appear. They just appear on a freaking disc, a CD. Poof. And it's 6 months, 7 months later. Like, get the fuck out of here. Take that video and go shove it up recording and shove it straight up your fucking ass. It's not coming in. Unless you say, hey, let's use it because we're about to F you. Because we need it to show X, Y, and Z. Which is what they went with in this case. So there was a decision we made, but it's like there's no chain of custody on any of this stuff. So because the defense was being broke off little pieces. It'd be one thing if you have a disc. Okay, here's your disc. And then they have 30-minute clips because it's too large. So we broke them all off into, 20, 30-minute clips. And so it would be like, and then you would label the times on the file and then you would click them. That's not what they were doing at all. It was like they were taking a donut and sprinkling it with sprinkles. Okay. Next. The footage produced by the Commonwealth is rife with issues that call into question its accuracy and forensic viability, including the presence of the inverted video and the large-scale gap missing from the feed at the precise time at which Miss Read's Lexus should be shown entering the CPD Sallyport garage. In spite of the fact that the Commonwealth claims the video surveillance feed is motion activated, the fact that the Canton Police Department produced video surveillance with an inverted video and a gap in the footage at the critical moment, i.e. the precise time Miss Read's SUV arrived at the CPD garage, is not trivial. How can it be motion activated and you don't catch it with the movements of the car going in the garage and everybody just dancing around it? That's movement. Like, who believes this shit? Nobody believes it. Nobody believes it unless what? Well, of course, unless you're the officials. Right? Unless you're government officials over there doing God knows what. It's all a bunch of crazy bullshit. This is going to be the fastest verdict of not guilty, I think, ever. The motion to reconsider reciprocal discovery is good. Yo, it's money. This is it. Hi, good morning. Welcome to the transparency. Good morning, you guys. It is 9:35. Everybody get your tea going because we're about to get the train going here. In preparation for trial, the defense requested access to the Canton Police Department CPD DVR system and drives that hold recordings from the CPD security camera system so that the defense expert, Mr. Erickson, could obtain video files in their native, not what I wanted, in their native, where was I? God bless America. Yeah, in their native file format with available metadata. along with any associated logs files. The way CPD technicians extracted the video data from their DVR system is insufficient for forensic purposes and has resulted in the permanent loss of the original surveillance video data. Excuse me? Right here. The way CPD technicians extracted is insufficient. Now, I'm going to tell you what I believe that this sentence is for. Hank is going to come back swinging. This was a trap. This was such a trap. Give it up for whoever wrote this motion, which we think it's Little, right? We think Little wrote this. This is a trap because Hank's going to go crazy about this. He's going to come back saying that that did not happen. Okay, prove it didn't happen. Where's the video? You can't defend it. You can't defend it, but he's going to get his panties in a twist. Okay. The CPD DVR system, like most, stores videos in a proprietary format. CPD uses the DVR interface to pick and choose which videos to save, and then that data is converted by the system into a playable format. This would have been one of those situations. The resulting file is almost always of lesser quality than the original. And because it exists in a different format, the resulting file will not hash verified to the original. As such, forensic experts cannot properly test the authenticity and integrity of the video footage. I mean, this is just, ooh-wee. Okay, Sherry. I just needed the 479. We got that 479? Let's see if we got that 479. What is that 479? Mark Bedrow, welcome to the team. Why is this labeled? Oh, it's not 479. It's 483, right? The hell? The hell? The hell? Why is this listed at 47? I don't want that one. 483. Yeah, this is what I want. Again, welcome everybody. Truth and Transparency. Subject line has number. Oh, it's just my phone though. It's crazy. You guys, if you guys even knew what my desk looked like right now. I got case law for days over here. For all this Ohio shit I'm doing. I got case law. I got shit everywhere. Penny, thank you. Thank you. Oh, yeah, no, it wasn't you guys. It was me. It's all me. I download the new software for the iPhones. Ugh. Just shoot me. I'm not happy. You know, when that just happens, you're just like, I got to get used to that. So anyways, all right. The rest of them are here. We can do this. Let's see. Yeah, this is way better. Okay. In response to the defense's request, Special Assistant District Attorney Hank Brennan agreed to allow defense access to this critical information and to make arrangements necessary for Mr. Erickson to extract video from the DVR system. Yeah. It's so, you can't prove a negative. Exactly. Very difficult to prove a negative. Remember, we know about all of this, about how he had to fly. So I'm going to skip over that part. I mean, you guys should know about the expert having to come. So facts related to attempts to meet and confer. After Ms. Reed expended, significant resources to send an expert to Canton Police Department to image the DVR system on January 22nd, 2025, Defense Counsel received a call from Special Assistant District Attorney Hank Brennan indicating that he recently obtained information that a retired Canton Police Department officer had downloaded the surveillance footage at issue on his work computer and cloud-based account. He informed the defense counsel that he was going to have his own expert download the surveillance footage, but would permit our expert to fly back to Canton to be present for the imaging. At the hearing on February 6, 2025, the court invited both parties. So this is where we would have left off at if you guys have been following with us last week. Okay, this is where we would have left off. And so this is the goods. So where are we? Remember, I was like, hey, why aren't they just meeting? And why aren't they just doing this on that day? Like, what's going on? Alan Jackson's there. Yannetti's there. Hank, let's go take care of this. Well, let's see what happens. So at the hearing on February 6, 2025, the court invited both parties to meet and confer informally on the issue of the video download in order to obviate the need for further court intervention. The defense did this in good faith. On February 6, 2025, defense counsel met and conferred with the Commonwealth regarding obtaining the requested video surveillance footage and associated information from what has been varyingly referred to by the Commonwealth in separate discussions as a retired detective's work computer. So clearly, she's using these quotes for a reason because something's up, y'all. This is how it's been referred to us. This is how we're referring to it. And the Canton Police Department's detective file. Now that's interesting. Okay. I thought that the Canton Police were not on this case. I thought this was that they were out due to conflict. Okay. Following that meeting, Attorney McLaughlin sent an email stating that, quote unquote, the Commonwealth will attempt to download any videos to the extent they exist. I think it's interesting that she is writing this. Okay, Hank's been dealing with this. Now she's going to be writing this. So following the meeting, Attorney McLaughlin sent an email stating that, quote unquote, the Commonwealth will attempt to download any videos to the extent they exist, which are related to your client's vehicle at the Canton Police Department and presently stored on the department's video file system. Excuse me? The department's video file system? What's this now? So we got hella problems right here, if you ask me, with that. The Commonwealth will video the process and produce documents of the retrieval process and any responsive videos. I thought that they meant to do all of this. Like, what's going on here? And again, she says, see Exhibit 2. Attorney Little responded requesting that the Commonwealth's expert conduct a full forensic image. We don't want you doing anything. We want you to do this first. Okay, it's like you take a phone and we want you to forensically image it. Okay? That's what we want you to do. We need this. We need this. Done together. So we want a full forensic image of the computer and or video file system at issue such that our expert can obtain a copy of all available metadata. You need this to determine lots relating to any of all the videos at issue, including any log file associated with the videos and or deleted data. We want the image. We want it the way that it is. We don't want you doing anything else. This is what has to happen first, okay? Like, are you like, it's like, hey, we have to learn how to read. Okay, well, don't you have to learn how to, like, what these letters are, how you sound them out? We're just going to read without, like, and they know what they're doing, you guys. This is not like they know what they're doing. They know what they're doing. Special Assistant District Attorney Hank Brennan then responded. So now we got Hank indicating that the Commonwealth would not be obtaining a forensic copy of the information at issue. Why? Would not be obtaining. Why? What's anybody hiding here? When Attorney Little requested that the Commonwealth, quote unquote, ensure all metadata associated with the related files and any associated logs are copied onto a thumb drive, Attorney Brennan objected and indicated the defense would need to file a motion with the courts. So he's like, no, go file the motion with the courts before we do any of this stuff. And they have to, because he's going to argue. Okay, what's being set up here is two things. First of all, this is an opportunity, if you really want me to be honest. This is an opportunity for the bad actors to literally destroy evidence. And it's going to cost them the Karen Read case, which means they're not going to be able to prosecute Karen Read, but we're not going to be able to prosecute anybody else. So I'm buying you guys time if you guys want to destroy this shit, which means we're going to lose the Karen Read case, but it'll protect all you guys that have been bastards. Okay? That's number one. Because I can promise you right here, you don't have an objection to this. Okay? Not after the statements that you just made in open court last week. Okay? But I'm telling you, what's on that video, if everything that Karen Read's team is saying happened, would be on that video at some point. If it wasn't, they'd have no problem turning it over from jump if they didn't do anything like that, right? But here, it's like, this shit exists, and well, Heather, that's exactly what he said. He said he'll get the video footage. He never said that we'll get you the forensic video image of it. So he wants to play with words, but I'm telling you what this is to do is they're using the public docket, you guys, to send smoke signals to the bad actors. I'm telling you, this is the only way that you could do that. You can use the public docket with motions to literally convey your messages. And the messages can come in many forms, because the people that did the wrong, that are in the wrong, they know then what they did, and they know then what that camera caught. All right. So Hank is saying he objects. You're going to have to go get a court order. That's like somebody saying you're going to need to go get a subpoena. You're going to need to go get a warrant. Now, it could happen one of two ways. You could say that Hank Brennan's just doing his job and saying, nope, if you want that stuff, you go file a court order. Okay, well, the courts wanted us to work together, but that's fine. Now I'm going to go get that court order. And then you could also say, no, there's nothing to hide. He just wants it, done by the book? Well, I think the judge was saying at the last time that they were there is, y'all, can you get this together? So I have to kind of throw that out. 100 there, Heather. Yep. In my opinion, the video shows Higgins in same clothes, never went home, and him moving vehicle out of Sallyport and setting up tools, etc., for them to fuck with Karen Reed's vehicle when it got there. That's what Murky says. Well, in my opinion, the 42-minute video shows exactly what they did to Karen Reed's vehicle. But then I think they altered the time of the actual video. Because you can see the snow on the ground already. And so they redid and made it look like Karen Reed's vehicle was coming in for the first time when it wasn't, because remember the backing up into it? Remember that? I don't believe that those timestamps are accurate either. I think that that's why if you go back to the original, when what's-his-name was saying when they towed the car and what time it was and stuff like that, all those times were messed up. Yeah. Thank God, though, think about this. If Mr. Reed didn't have camera footage, if he didn't have a ring at his house, if he didn't have that, I mean, because then you're going to just have somebody saying, oh, it was just a typo. No, it wasn't. Like, if people don't get dash cams in their cars and go and get ring cameras at their exit and entry points of their houses, then, the government has used surveillance in their favor, just kind of like when we didn't have DNA, they used it in their favor for cases. Now DNA is able to exonerate you, and now surveillance cameras and the police's own body cameras, they're being used to do what? Fuck them and help us. Unless you have shitty cops that purposely cover up their body cams and fuck with that shit. But the digital world can help us, especially all the new changes that are going to be coming with the privacy stuff that's going to start coming up with our phones, and like you just going and getting fucking naked warrants for our phones. Our phones are like our houses back in the day. To go into each part of my phone, like, okay, all you get to go is you get my contacts. That's it. You don't get to go on my phone and look at all like my medical stuff, my chart. Get out of here. No, you don't. You don't get all the pictures on my phone. I have a right to privacy to think that if I'm having sex with somebody and I want to video record that, you don't get that shit, right? Think about that. Nope, well, we got your phone. No, you don't have no, and no. And I think it should be called the Proctor Law. I think the Proctor Law needs to come out from this, and because him doing exactly what he did, and he admits it in open court, is exactly why it should be the Proctor Law. So bring it on. The Proctor Privates. Proctor's Privates. Fuck yeah. Sign me up. That's my book on the Karen Reed case. I'm going to write a book called Proctor's Privates. Oh, hell, Lana. Yes. Proctor Privates exposed. Fuck yeah. Love it. Love it. Okay, going back. When Attorney Little requested that the Commonwealth ensure all metadata associated with the related files and any associated logs are copied onto a thumb drive, Attorney Brennan objected and indicated the defense would need to get a court order. Okay. So on February 6th, here you go. This is how Little responded to his little bullshit. Okay. If the Commonwealth is objecting to properly forensically imaging the computer and/or department's video file system, such as that we can obtain the information we have been requesting, namely all video footage from the Canton Police Department on January 29th, and all metadata and logs associated therein, then I will file a motion with the court tomorrow. This information needs to be obtained in a forensically sound way. That is all we are asking to have happen. And his pants just literally, panties twisted. Panties twisted because we want to have a forensic image so that it can be saved in a forensically sound way. Because that's the only way that experts can deal with stuff. Okay? As of the filing of this motion, the defense has received no response from the Commonwealth. The defense does not want to expend additional resources to send an expert to obtain this information. Rather, this is what we're asking for. It is simply requested that the Commonwealth, which has retained not one, but 2 digital forensic experts, forensically image the device in question to ensure that the data is obtained in a forensically sound way. Remember I told you guys all those times that they say forensically sound way, we are taking a shot. That's why. So absent this court's intervention, the Commonwealth will be permitted to destroy critical metadata underpinning one of the most seminal pieces of physical evidence in this case in violation of Brady. What a bunch of pieces of shit, you know? Pursuant to Brady, this is the argument. Pursuant to Brady, which mandates that the prosecution turn over all this, you guys, the argument is what it is. Okay? Here, the requested video surveillance footage and accompanying metadata constitutes tangible evidence that is clearly relevant, material, exculpatory, and necessary to Ms. Reed's ability to defend herself at trial. Moreover, on October 5th, 2023, this court ordered the Commonwealth to produce all video evidence obtained in connection with this case, along with all associated metadata. See Exhibit 1 again. The defense is simply asking for this court to, I would say, uphold your fucking order, but to order the Commonwealth to obtain and log this evidence in a forensically sound manner so that no additional exculpatory information is destroyed. Karen Reed's taken down everybody. Let's just be honest. Okay. So basically what this means is that there's proof, okay? Because remember I told you, like, let's get the RICO going. This is proof that there's evidence that would have the dates, timestamps, people that were involved, and who the only the personnel that could have been doing things like who inverted the video. Okay. Who, you guys took this name out to us, like, that said that he's the one that, recorded it. Because you guys keep breaking us off these pieces. It's like, where are all these pieces coming from? Well, then somebody let it out the bag that this guy had it. So that DiGeronimo, or whatever the hell his last name is. Now, Karen Reed did an interview with Boston, Ted Daniels, and immediately, Commonwealth's motion for records. You guys, I don't know if Karen Reed was trolling Hank Brennan here. Okay. Yeah, that's him. When she decided to say yes to Ted Daniels, I'm going to tell you what I think. There is no information in that little 6-minute clip. I personally believe that Karen Reed and her team trolled Hank Brennan. And I'm going to tell you why. Because of this. Okay? Because of this. Hey, let's say that we're going to be doing an interview, okay, with Homie G. Hank Brennan is then going to go and do what? He's going to go and do this, right? This was moving a pawn in order to take a queen. And Hank Brennan fell right in it. Now comes the Commonwealth and respectfully request this honorable court pursuant to Commonwealth v. Lampron issued to order keeper of records, ordering the keeper of records, Boston 25, to produce the criminal clerk's office of Norfolk Superior Court, all unedited video and audio recordings of all interviews between the defendant and Boston 25 reporter Ted Daniels. All written and recorded statements of Karen Reed, and any interview notes or memorialized statements made or adopted by Karen Reed. Karen Reed being monitored. Hey guys, guess what? I interviewed Karen Reed 3 nights ago. I recorded everything. I took such amazing notes. I have like 4 devices that it's all backed up to. Is Hank Brennan going to, file a motion to get all of truth and transparency stuff? Get to the motion to reconsider reciprocal discovery. Really good stuff in there. All right. Due to Mac Dick. I like that name. Mac Dickles. We'll read that. I think Karen just talked about her diet. I think Karen talked about, there was nothing that came out in that interview. So let's see. God, they were just, everything's getting produced. What number is it? Mac Dick, what number? Get to the motion to reconsider reciprocal discovery. Good morning, people. I think we have, I just need the number. I have them all by numbers. There's like, I swear every other day there's a new freaking filing. On February 6, 2025, Boston 25 began advertising the biggest interview of the year. A sit down with Karen Read, you guys, after the Super Bowl. It was the biggest shit down. It was such a letdown, but I think it was for number 493. Okay. I just think that Karen Read trolled Hank. I think it was great play. Here it goes. I think it's amazing. I think that they talked about wild shit, like shit that doesn't matter. So that's my personal opinion. And the next document up is the reciprocal discovery. Penny's printing it now. Penny, you're fired. Get over here. There you go, Penny. Push it out there. Well, I saw that when that was asked, Alan Jackson stepped right in really quick and said, "We don't know." He wanted me where he was cutting off Karen there. We have no idea who killed John O'Keefe. All right. So now comes the defendant Karen Read and respectfully moves this honorable court to reconsider its reciprocal discovery order regarding the defense pretrial production of impeachment evidence related to the Commonwealth's anticipated trial witnesses. As ground for this motion, the defendant states that the production of impeachment evidence prior to witness testimony is not required under Mass Rule 14A1B and will unduly prejudice the defense by allowing witnesses to tailor their responses to preempt cross-examination. I read this last night. So we'll go like this. This motion shows how gatekeeper can kneecap defense, shows that the Commonwealth is running a reverse prosecution defending the McAlberts. They really are. So we'll get to that. Here we go. And let's make sure it's straight. Got to have it straight. Get everything straightened out here. All right. So factual background. Miss Read is accused of the following crimes arising out of the death of Officer John O'Keefe, murder in the second degree. You know all that. So Miss Read faced a trial by jury for the above crimes being on April 16th. Prior to the commencement of the trial, the Commonwealth submitted a motion for reciprocal discovery and notice of any experts filed on March 21st with the court. Paragraph 4 of the Commonwealth's motion requested production from the defendant of quote unquote, any written or recorded statement, as well as any oral statement reduced to writing of any individual whom the Commonwealth intends to call as a witness at trial. including but not limited to such statements contained in defense investigator reports or other non-legal reports. See Commonwealth's motion for reciprocal discovery and notice of any experts. The Commonwealth's motion was allowed by this court. It was allowed by this court. Damn. Duh. Shit, right? Requiring the defendant to turn over evidence intended to be used as impeachment evidence against witnesses called by the Commonwealth prior to those witnesses being called to testify at trial. On several occasions during various Commonwealth witness testimony at trial, the witnesses subsequently tailored their testimony and included details which had not previously been discussed to account for the impeachment evidence turned over by the defense. Now this makes sense as to why Alan Jackson was asking, because you had that material, because that's why Lally called you in for a meeting. Oh my God. You guys understand that, right? So when he asked Jennifer, when he asked anybody, what did you do to prepare for this? What did you do to prepare for this trial? When did you meet with so-and-so? When was the last time that you met with so-and-so? Meaning the Commonwealth. And Alan Jackson was highlighting that they met after the defense produced this material. So they could tailor their testimony, so they could add stuff to their testimony. For example, at trial on May 21st, 2024, Jennifer McCabe testified for the prosecution. During cross-examination, Ms. McCabe testified that on January 30th, 2022, the day after John O'Keefe had been found in front of 34 Fairview Road, she went to the house of Canton Police Lieutenant Michael Lank. Prior to this testimony, Ms. McCabe had never disclosed publicly or in any report or witness interview, even when asked directly about her meeting and conversations in the days and weeks following January 29, 2022. Remember that this was a big point of contention. Estrella says, this document blew me away. Oh, yeah, this document's nuts. So following January 29, 2022, that she visited the house of one of the responding officers to 34 Fairview Road. Ms. McCabe, who is quote-unquote friendly with Mike Lank, and end quotes, and quote-unquote knew of him growing up, end quote, testified that she could, quote, could have been at Lieutenant Lank's house for an hour. After initially denying having entered Lieutenant Lank's house during the hour that she was present, she then remarked how she, quote, might have ran in to go to the bathroom, end quote. When asked why she had never testified to this incident before, Ms. McCabe responded, I guess I never thought much of it. The only time Ms. McCabe responded, I guess I never thought much of it, the only time Ms. McCabe claimed to have discussed this meeting with anyone related to the case was at the DA's office with Mr. Lally, Miss McLaughlin, Stephen Nelson, and Trooper Brian Tully. Now is it all coming back to me now? This is absolute wild. This is prosecutorial misconduct too. It's like, this is crazy. This is crazy. And you're going to tell me that the feds are going to just sit there and not do anything about this? I guess it's just never thought much of it, you know? So Mr. Lally, Miss McLaughlin, Steve Nelson, and Trooper Brian Tully, that's who was all there. Miss McCabe confirmed that at that meeting with the prosecution, she was specifically asked about her meeting at Lieutenant Lank's home, something which she had never revealed and about which she had never previously been questioned. At trial, she saved this information for cross-examination. After questioning Ms. McCabe about a different topic, Attorney Jackson asked Ms. McCabe, did anything significant happen on January 30th in connection with this case? Any meetings? Any get-togethers? Anything that you can think of? McCabe responded, I went to the O'Keefe's house. Attorney Jackson followed up with, other than that, anything else? In response to this open-ended question, without any indication from Attorney Jackson regarding the answer he was seeking, Miss McCabe volunteered this thorough answer. God, I fucking love when people get quoted and get drop your pants. On the way home, Carrie Roberts' daughter is good friends with Michael Lank, so we dropped her off at Michael Lank's house, and Mike's wife came out of the house. Him and Carrie are friends, and she, jumped in the car and was consoling Carrie and asking how the O'Keefes were doing, and, we talked to her. Oh, my God, you guys. This is how you use the public record to really get out the Bev. This is what you call a fuck job. This extremely detailed and comprehensive explanation as to answer to Attorney Jackson's open-ended question, accompanied by Ms. McCabe's testimony that she had been asked about this meeting by Mr. Lally at the DA's office, leads to the inescapable inference that Ms. McCabe was prepared for this impeachment question in advance of trial. That was only possible because, in compliance with this court's impeachment evidence reciprocal discovery order, the defense had turned over location data obtained from Ms. McCabe's cell phone to the prosecution on May 6, 2024. This location data showed that Ms. McCabe was indeed present at Lieutenant Lank's personal home for approximately 45 minutes on January 30th, 2022. Although the Commonwealth did not elicit this information during its direct examination, Ms. McCabe had clearly been prepared for the question on cross-examination as a result of the defense production of impeachment evidence. This is disgusting. Another example occurred at trial on May 28, 2024, when PF testified for the prosecution. Oh my God, no way. "11 years old at the time." Oh my gosh. No. Tell me it ain't so. Oh my gosh. And now he was 13 at the time of the testimony. Described his experiences with the defendant during a SANE interview on February 22nd, 2022. PF had testified about an incident with the defendant wherein she got really mad at him. PF described how one time I had like steak tips and I was just eating them slowly because they were hard to chew. And she got really mad at me for it because because she thought I didn't like them and I was spoiled and stuff. See the SANE interview. Oh gosh. During trial testimony on May 28, 2024, PF was questioned by the prosecution about the same incident. Prior to that testimony, Attorney Yannetti expressed his concerns about this line of questioning at sidebar, stating that there was testimony in the grand jury about my client supposedly getting mad at PF for eating his steak too slow. We provided a video of the incident to the prosecution, which belies the testimony. Attorney Yannetti was expressing his concern that PF's trial testimony would diverge from the grand jury testimony as a direct result of the defense production of pure impeachment material to the prosecution on May 6, 2024. This is, of course, exactly what happened. Mere minutes later, PF was asked by the prosecution about instances where he was yelled at by the defendant. He recounted one time he got takeout food and I was taking a little while to eat it, and the defendant, though I didn't appreciate it, so she got mad at me. May 28, 2024, with sidebar. 2 weeks prior to his testimony at trial, the defense turned over a video depicting PF eating steak tips, interacting with Miss Reed in a playful manner, wherein she never gets mad, directly contradicting his sane interview from February. PF undoubtedly met with the prosecution in preparation for his testimony. This resulted in PF changing his story to claim that it was takeout food and not steak tips that he had been eating, so that he could now claim that the defense impeachment video does not depict the incident he initially revealed. This is therefore another example of the prosecution using impeachment evidence produced by the defense pre-trial to coach witnesses to change their testimony during trial. This unfair use of impeachment evidence creates an undue burden upon the defense or upon the defendant and should not be permitted. This is sick. This is so sick. To include a kid in this and to do this. This is the argument. What's a sane interview? It's with like the child services type of people. Sane is a like SAIN. If you just type that in, it'll come up. Type in that with Austin. The prosecution of statements by adverse witnesses is not subject by mandatory disclosure under Rule 14 and must be sought by motion. So their argument is that the Massachusetts rule outlined the cases of materials subject to automatic discovery or materials mandated by rule to be produced by the prosecution and the defense without need for a motion before the court. And then citing those and then saying that statements of those persons whom the defendant intends to call as witnesses at trial. Emphasis added. Rule 14A2 allows for the defense and the Commonwealth following production of discovery required to move for discovery of other material and relevant evidence not required by subdivision A1. A distant line has been drawn under Rule 14. Between materials subject to automatic discovery and materials discoverable only by motion. See Commonwealth versus Durham. Automatic discovery does not extend to statements that the defense intends to use for purposes of cross-examination. In a given matter, the prosecution and defense are only required to produce statements intended to be used at trial, which are attributable to their own witnesses subject to Rule 14A1. CID. Statements attributable to adverse witnesses, example, statements attributed to a prosecution witness that the defense intends to introduce at trial are not subject to Rule 14A1, but instead can be ordered production by the court in response to motion under Rule 14A2. So a trial judge has broad discretion with respect to motions for production of non-automatic discovery subject to Rule 214A2. A judge has discretion to deny a movant's motion for discretionary discovery materials when the movant fails to establish, quote unquote, a threshold showing that the material he or she is seeking is relevant. The policy for Rule 14A2 is based on the concept of reciprocal and has as its aim full pretrial disclosures of items normally within the range of discovery. Basically, they're using, so here they say it. Here, the Commonwealth's request for production of statements of individuals that they intended to call at trial was not information subject to the automatic disclosure requirement under 14A1B, as they were not statements of witnesses intended to be called by the defense. Thus, production of such statements was subject to the court's discretion based on a showing of the relevant nature of such evidence and the aim of fair disclosures for trial. Wow. The production of impeachment evidence prior to witness testimony has created unfair prejudice to the defense and has undermined Ms. Reed's right to confrontation. Holy shit, this is so true. Rule 14C1 of the Massachusetts Rules of Criminal Procedure is the mechanism for sanctions. They're asking for sanctions. They should be disbarred for this. In response to violations of discovery orders pursuant to automatic or discretionary production orders rule or discussed in Rule 14A, sanctions may be imposed upon non-complying parties to basically remedy the violation in a way the court sees fit. Sanford describes the two tenets of sanctions under Rule 14C1. First, sanctions are remedial in nature. Second, sanctions should be tailored appropriately to cure any prejudice resulting from a party's non-compliance and to ensure a fair trial. Purposes of such sanctions must be not punitive. So it's not for the purpose to punish you. It's just for the purpose for remedy. So you're trying to remedy the situation. We're not doing this because we're punishing you. So the sanction that they're asking for is, listen, we're not doing this time around. Okay? This isn't happening in trial 2. There is going to be none of this because this is what they did with it. And rightfully so. So, I mean, this is sick. This is sick. Similarly, when a sequestration order in place with respect to witnesses at a trial is violated, the judge has discretion to remedy the violation, including to admit or exclude the testimony or witnesses who have violated the sequestration orders. Commonwealth versus Jackson, citing Commonwealth versus So the Commonwealth or the Massachusetts Rules of Criminal Procedure give judges the discretion. So again, this is going to be up to the judge. The defense's production of impeachment material pursuant to the court's allowance of the Commonwealth's motion for reciprocal discovery clearly altered the trajectory of the Commonwealth witness testimony. Sure did. Additionally, the defense believes that the violation of the sequestration order occurred during the first trial. In addition to the inclusion of testimony not adduced at previous hearings, a message from one of the witnesses from the first trial demonstrates that at least one witness likely violated the sequestration order with the knowing of this prosecution. So I believe that what they're saying is, because I always thought it was weird, is why is Tully able to be in? Why was Tully able to be in any of those interviews or meetings? So what I believe that they're saying here is that there was a violation also of, like, these witnesses, everybody was sequestered or supposed to be, like, you can't be in the courtroom. Remember they were asked in regards to, like, Colin Albert's family. So have you talked to your dad about this? Have you talked to your mom about this? Like that type of thing. And so here, I believe what they're referring to in this is that by the prosecution meeting with the witness, right, and Tully would have been there. Tully's a witness in this case. But sometimes if you want them to be able to be present, so was Tully allowed to be there because he was there every day? Was he in the courtroom every day? Because he was like the DA's right hand. But on July 1st, 2021, at 5:48 and 21 seconds, prosecution witness Trooper Michael Proctor sent a text message to, oh God, they're going to use that. This is insane. Oh my God, here we go. Oh no, say it ain't so. So on July 1st, 2024, at 5:54 and 21 seconds, prosecution witness Trooper Michael Proctor sent a text message to Assistant District Attorney Adam Lally that stated, yeah, didn't watch asshole Jackson's closing for good reason. Like all of us, the anticipation and anxiety of a verdict has us all on edge. End quote. Oh my God. Dumb Lally. See screenshots of Proctor's text messages to Lally from July 1st, 2024, subject to protective order due to personal identifying information. Mr. Proctor's message suggests that his decision not to watch the proceedings on July 1st, 2024 was not out of effort to abide by the sequestration order, but was instead related nature of the defense closing argument itself. The message implies that Mr. Proctor had been following the trial online and simply skipped the defense closing argument because he does not like Attorney Jackson. Oh my God. See, I wondered about that. I wondered about, like, okay, if there's this sequestration order, but this is on TV, like they're not supposed to be watching it on TV. And I knew that. But I said, God, like that's happening. You know what I mean? Like, come on. They can just, you don't want to watch it from your phone. There's no evidence of it, but you would just go and watch it on your television or somebody else's, go to a bar and ask them to turn it on like I wanted to do. This is insane. Even absent this admission, the unique nature of this case, including pervasive media coverage and real-time streaming of the in-court proceedings during trial, creates opportunity and temptation for witnesses to watch the testimony of others in violation of the sequestering order. The risk of even inadvertent witness exposure to trial testimony, such as the witness would alter their testimony or anticipate otherwise unexpected impeachment material, would be cured by the court modifying the reciprocal discovery order to exclude defense impeachment material. Oh, good job. Good job. Notice how little isn't like, yeah, the remedy is to not let this be on, like cameras in the courtroom. Like these other fucking attorneys that do it out there. There should be no cameras in the courtroom. Like that's the sign of a good attorney. Like, no, they're just not going to get, like, we're not giving you this stuff now. Apparent violations of the sequestration order allowed, coupled with the defense's production of impeachment material, allowed prosecution witnesses to either, one, preempt cross-examination topics by first addressing damaging information during direct in an effort to take the sting out of the cross-examination, or two, have polished answers prepared when asked about the same topics for the first time during cross-examination. The inability for the defense to be able to properly confront prosecution witnesses with impeachment material without giving those witnesses the ability to devise a way to incorporate the material into their revised testimony, creating an undue prejudice to the defendant and improperly controverted the intended purpose of the mutual discovery rules contemplated by Rule 14 of the Rules of Criminal Procedure. When the defense has impeachment material it intends to use at trial, the presumption should be that it is not discoverable before trial because, quote unquote, generally a defendant need not reveal his defense, end quote. Boom. That's a big boom. Commonwealth versus Edwards. The defense acknowledges that allowing the defendant to withhold evidence against a witness who is certain to be called to testify would undermine the discovery rules and allow attorneys to return to trial by ambush. Theatrics do not accord with our discovery process. That's in Durham. That forceful quote, however, is in opposition to the present issue. After all, the defense is not requesting to withhold impeachment evidence until the very moment that the evidence would be sprung upon the witness on the stand, rather in an effort to avoid impropriety rather than create it. The defense merely requests to withhold impeachment evidence until after the witness has testified on direct examination, such that the witness cannot unfairly preempt the confrontation. Once the witness's testimony is recorded, the defense would produce the relevant impeachment evidence that they intend to use upon cross-examination to the prosecution so that they can adequately prepare for the redirect examination. Wow. This is why its intended purposes are for. And we're asking, since they didn't, hey guys, we're like 4-year-olds here. They were playing with the toys and broke them on purpose so that we couldn't play with them anymore. Like when it would be our turn. Okay. So since they can't have nice things, the purpose of sharing, right, is not so that when you get it, you break it. So that it fucks my playtime. So here we need the teacher to intervene and say, hey guys, this is what we need. We need you guys to do X, Y, and Z, which is, we're not going to offer our toys anymore to have share time. Okay. We're going to offer our toys, after you guys went ahead and played with yours. Now I get to add my new toys into the mix. But before I hand them over to that person to play with those toys, you can inspect them. Here we go. So I think this is huge. I think this is absolutely unbelievable. Like, what do you think the response is going to be? So now Hank Brennan has to sit down with Lally and say, what the fuck? Is this what y'all did? Is this what y'all did? No, we didn't do that. Well, then how did they know about this shit? How did they know about this stuff? How were they prepared for this? And an officer of the court, like Hank Brennan, what are you going to do? What do you think, Adam, like... Adam, let me see your notes from the first trial. Oh, it looks like you sat down with him and this is what you did. Because here are your notes right here. Where are your notes from the first trial? Where are your notes when you met with these people? I'm not going to have you sit here and lie to me. This is a joke. Wow. As a matter of procedural posture, as the court and parties are well aware, Ms. Reed is facing a retrial as a result of an initial mistrial. Nearly all of the civilian and law enforcement witnesses that will be called in this matter have already testified at least once, and sometimes 3 or more times under oath, either during the state grand jury proceedings, federal grand jury proceedings, or during the first trial. The only witnesses who appear to have not testified to this point would be a small number of experts who may yet be subject to voir dire. To the extent the defense sought to maintain any element of surprise, and the defense would suggest that Ms. Reed has been far more forthcoming than most criminal defendants prior to her first trial, much of that surprise has already been foiled. What the defense requests now, that the court not order the defense to produce impeachment material, will aid in balancing the need for reciprocal disclosures contemplated by Rule 14 with the need for remedy discovery measures to protect the defendant's right to a fair retry. The preemptive impeachment materials by prosecution witnesses is unfair because the record clearly demonstrates that the witnesses discussed above, including PF, Lieutenant Lank, Jennifer McCabe, and Mr. Proctor, either prepared for impeachment evidence prior to testifying and changed their testimony from earlier occasions, or likely violated the sequestration order of this court. The defense is requesting that the court modify the order for reciprocal discovery only to the extent necessary to prevent prosecution witnesses from using pretrial production of impeachment evidence to tailor their responses. Wow. That's what they're asking. As the interests of justice require. Whether the aforementioned violations are characterized as violations of the discovery order or the sequestration order, the court is empowered to impose sanctions ahead of Ms. Reed's retrial to remedy the threat of injustice under either scheme. Finally, the defense is not requesting the court for permission to engage in trial by ambush. Nor engage in theatrics. The effectiveness of cross-examination often depends on being able to surprise a witness, particularly an accusing witness, with evidence that contradicts or is inconsistent with his trial testimony. A second trial following state and federal grand juries and an extensive first trial can hardly be called trial by ambush. So they're giving them all these opportunities, they're showing them how by you doing this, this is far from a trial by ambush. Hello, there's all this material out there. Like, this is just ridiculous. This is fucking sick. I don't care. This is sick. Yeah. Karen Reed, this motion to dismiss is going to be off the chain, like literally off the hook. So the defense is simply requesting a fair and equal opportunity for each party to be confronted or to confront their adverse witnesses with impeachment evidence without each witness being able to review such material and alter their responses accordingly. I would have said with the Commonwealth. Ridiculous. Yeah. I think this just goes to show the Commonwealth was in cahoots with all of these witnesses when they want to say this, Jen McCabe isn't on trial. This person isn't on trial. This person isn't on trial. These people may not be on trial, but you sure as hell made them. They should be on trial. Your interaction with them, it's one, I get that you want to protect your case, but you're protecting people. You're protecting people, not your case when you're doing this. You're protecting people. And so you have to ask yourselves, why would the Commonwealth be protecting people? Why would I, as a district attorney or as a prosecutor or any attorney for that matter, want to, you're protecting somebody that you knew lied. That's misconduct. That's under, that's, I don't know how many of these people are, how do they have their license still? Anyways, thank you guys for joining me this morning. This was crazy. It's going to be, I didn't think Karen Reed had a chance to win that. They just need to change stuff. Karen Reed wasn't going to win that to say that these are off the table or anything like that. Hopefully what happened to Karen Reed, it changes things moving forward. And I think that it will. But I think Karen Reed's going to literally kick the teeth in of the Commonwealth in round 2. And then she's going to have round 3, 4, 5, 6, 7, because she's going to take out the whole damn, she's going to take them all out. I would be using this, if I was her, to get as much information to take these fucking pieces of shit down. They all tried to frame her. And when I say they all, like everybody, to include the fucking prosecutor's office. Adam Lally just wasn't doing his job in prosecuting a case. You don't have interviews with witnesses after reciprocal discovery has been provided for you or to you for the purposes to give it to them, to prep them for their cross-examination where they're about to get bent the fuck over. That is not what you do. So Adam Lally wasn't just like, oh, he's the only guy that we have to put this on. No, Adam Lally is involved. 100%. Adam Lally is a big boy that has a fucking mouth and could say, no, I'm not doing this. Adam Lally makes his own decisions. Do not let that fucking asshole out of anything, Karen. Unless you want to cut a deal with him to take down every single body else, okay? Which he may give you that but that's the only thing that he's worth. Is it from him giving you everything? It's the only way you let that fucking piece of shit out. And see, for me, I'd want them all. I'd say, fuck his info. We'll get him. He's the one that prosecuted you. I'm not cutting him a deal. He's the one that cheated for these other people against you to frame you for murder. That's the last person I'm cutting a deal with. That's the last person I'm going to, okay, hey, if you give me, no, fuck you. I'll get you too. Don't worry. I'll figure it out. We'll figure it out. You know what I mean? Fuck him. Fuck all these people. Go, Karen. February 18th is reserved for any evidentiary motions or voir dire hearings. Yep. So we're back in the courtroom with Karen Read next week. I know that they had to have some, what's today? Oh, so Monday of this week there were some deadlines that they had to get some stuff in. I just can't wait I want this motion to dismiss. This motion to dismiss is going to be awesome. But see, also it's a strategy thing too. If you pile all your shit into this motion to dismiss, you're giving up your hand a little bit with the case, like with the trial. So that's where it's also going to be strategic with the motion to dismiss. So much love to everybody. Karen Read. I love that people that can donate, go donate to her. She deserves it. You don't do this shit. This is what you do not do. Yeah. So with that said, thank you so much. Hit the thumbs up on your way out.
We are not afraid of whatever evidence is unearthed from whatever source, because for 15 months, every stitch of evidence has been consistent with my client's innocence.
Not guilty verdict.